Imagine the world's largest democracy, right? A vibrant tapestry of cultures and languages, all operating under this one grand constitutional framework. But how does that intricate dance of power actually work at the local level? In each individual state, what are the precise rules, the roles, and those checks and balances that keep everything running smoothly? Or, well, sometimes not so smoothly.
That's precisely what we're here to unravel today. We're taking a deep dive into Part 6 of the Constitution of India. Specifically, we'll be looking at Articles 152 through 164, and then we'll jump ahead a bit to Articles 171 through 190. These articles, they lay out the fundamental structure of governance right there at the state level.
Okay.
Everything from the very definition of what constitutes a state to the crucial office of the governor, the Council of Ministers that, truly runs the show, and the intricate workings of the state legislatures, including their presiding officers and their administrative backbone. It's really foundational stuff.
And to guide us, we've got, well, a pretty dense, fascinating stack of legal scholarship here. Constitutional commentaries, historical analyses, key amendments, and crucially, those landmark Supreme Court cases that have really shaped how these provisions are interpreted over time. So our mission for you, our curious listener, is to extract those essential nuggets of knowledge, simplify the complex legal jargon, try to anyway, and reveal why these constitutional provisions are absolutely foundational to how a vast and diverse nation like India governs itself. Our goal is really to connect these, sometimes dry legal texts to the living, breathing reality of Indian state politics. Get ready for some genuine aha moments, hopefully.
Exactly. Let's jump in.
Defining the state and the governor's foundation, Articles 152, 157.
Okay, let's jump right into the very first article on our list then, Article 152. Here's, I think, an essential takeaway to start with. Before 2019, while this article set out a general definition for state in Part 6, it held this really unique, almost game-changing exclusion for Jammu and Kashmir, right? And that fundamentally altered how state governance applied there.
That's absolutely right. Article 152 provides what seems on the surface like a straightforward definition of what constitutes a state for the purpose of Part 6 of the Constitution, the part covering state governments. But its historical phrasing included a very significant exception, one that profoundly shaped the application of state-level governance for decades. It explicitly stated that the expression state does not include the state of Jammu and Kashmir.
Wow. So that single parenthetical phrase carried immense constitutional weight. It meant the entire framework for state governments we're about to discuss, everything from, say, the governor's role to how state legislatures are composed, it just didn't automatically apply to that one specific state. It signaled a completely different operational reality for J&K compared to all other states. Why? Why was this unique exclusion carved out?
Well, it's all about historical context. It links directly to India's concept of asymmetrical federalism. The idea that different states can have different relationships with the center. The original wording of Article 152 actually referred to states in Part A of the first schedule, which was a categorization that got abolished way back by the Seventh Amendment in 1956 during a major reorganization of states. This amendment then solidified the exclusion of J&K by directly stating it does not include the state. This wasn't an oversight. It was a direct reflection of Jammu and Kashmir's special status under Article 370.
Article 370, okay.
Exactly. So the unique governance structure for J&K was determined by Article 370 itself and the various presidential orders issued under it, rather than the general provisions found here in Part 6.
So if you were, say, a student studying the Indian Constitution before 2019 and trying to understand a governor's powers or a state legislative assembly's composition in Part 6, you'd know that for J&K, you had to look elsewhere. You'd have to refer to specific orders and constitutional applications under Article 370 to figure out how those functions or structures actually operated there. It really showcased how India's federal structure allowed for different states to have these, well, unique constitutional arrangements with the Union, acknowledging complex historical and political realities.
And the courts frequently weighed in on this, providing significant legal precedent over the years. Cases like Sampat Prakash versus State of Jammu and Kashmir back in 1970 saw the Supreme Court upholding the president's really expansive power to issue orders under Article 370. These orders could modify constitutional provisions in their application to J&K, even after J&K's own constituent assembly had dissolved. The court's reasoning basically underlined that Article 370 provided this special mechanism, making Article 152 consistent with this differential application for provisions in Part 6. Later, there was Maid Makbul Demnu versus State of Jammu and Kashmir in 1972. That case affirmed changes in J&K's head of state from Sadari Riyasat to governor, again affected through Article 370. These rulings, taken together, they underscored why Article 152 had that unique exclusionary definition. It was a constitutional acknowledgement of J&K's distinctive governance model at the time.
Right. And it's really crucial for you, our listener, to remember that this entire discussion around J&K's exclusion from Article 152, it reflects the position before August 2019. Constitutional changes since then have fundamentally altered J&K status, reorganizing it into Union territories. So this, a specific historical interpretation, it's a fascinating snapshot of a past constitutional arrangement, a powerful example of how the Constitution can adapt or, well, be altered, reflecting changing political and administrative realities.
Precisely. It's a part of constitutional history now.
Okay, now that we've sort of defined the state historically, let's move to a core component of state executive power, the governor. Here's what I think is the core insight for Article 153. Every state must have a governor, a singular constitutional head. But the Constitution cleverly allows for one person to serve multiple states. It balances principle with practicality.
Exactly. Article 153 is pretty straightforward on the face of it. There shall be a governor for each state. This establishes the office as a mandatory feature of every state, ensuring a constitutional head is always present. However, as you noted, a critical piece of flexibility was added later on. The Seventh Amendment in 1956 introduced a proviso, allowing the same person to be appointed as governor for 2 or more states.
Right.
And this wasn't just about administrative neatness. It was about efficiency, potentially saving costs, and providing administrative ease, especially in cases of temporary vacancies or perhaps for smaller states.
So, this governor, then, is the constitutional head, acting as this vital link between the Union government in Delhi and the state government. This link role, however, has often sparked a fascinating and frankly frequently heated debate. Is the governor merely a ceremonial figure, a sort of rubber stamp for the state government, bound almost entirely by the Council of Ministers' advice? Or are they, in certain circumstances, an independent agent of the central government with a distinct role in protecting Union interests within the state? This perceived dual role as both head of state and a potential representative of the center that seems to lie at the heart of many federal tensions in India.
It really does. For illustration, just think of it like this. Every state, from, say, vast Uttar Pradesh to coastal Tamil Nadu, has its own governor. But if, for instance, the governor of Punjab is also asked to temporarily oversee neighboring Haryana due to a vacancy, or maybe for administrative convenience, that's Article 153 in action. It demonstrates its inherent flexibility and the practical arrangements made possible within the constitutional framework.
And the Supreme Court has provided some crucial clarity on the governor's unique status over the years, hasn't it?
Yes, it has. In Hargovan Pant versus Dr. Raghukul Tilak, a 1979 case, the court emphatically stated that the governor's office is independent and specifically not an employment under the government of India.
That's a key distinction.
It's a very significant distinction. It emphasizes that while they are appointed by the president, usually on the union's advice, they aren't subservient employees. They're constitutional functionaries with their own distinct role and responsibilities, operating within the framework of the state's governance.
Which brings us back to that dual role idea.
It does. As the formal head of state, and often perceived as an agent of the center, while legally the governor is an independent constitutional functionary, the mechanism of their appointment by the president, invariably on the union's advice, frequently fuels political tensions. And this perception, or sometimes reality, of them acting as a representative of the central government really comes to the fore, particularly when their discretionary powers come into play. It's a tension inherent in India's federal structure, definitely.
Okay, so we know the governor is the constitutional head, but where does the real executive power of a state reside, and how is it actually exercised? Article 154 seems key here. The essential takeaway for me is this. While executive power formally vests in the governor, in practice, it's the elected Council of Ministers that wields this power, with the governor retaining only very specific, constitutionally defined, and, as we said, often debated, discretionary functions.
Yeah. Exactly. Clause 1 of Article 154 states it explicitly. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution. Now that phrase, in accordance with this Constitution, is critically important because it means the governor primarily acts on the aid and advice of the Council of Ministers, headed by the chief minister. It mirrors the president's role at the union level.
Right. The governor is the de jure, the legal head.
Exactly. While the Council of Ministers is the de facto or the actual executive.
Now, this is a key differentiator from the president at the union level, isn't it? The Constitution explicitly mentions that the governor may exercise certain functions in their discretion. That seems like a significant aspect of their role. Think about those politically charged moments. Inviting a leader to form a government when there's a hung assembly, or reserving certain bills passed by the state legislature for the president's consideration, may be reporting to the president about a breakdown of constitutional machinery in the state, potentially leading to president's rule under Article 356. These are situations where the governor's decision can become highly influential and, often, very contentious, acting without direct ministerial advice.
That's absolutely correct. And Clause 2 also includes important saving provisions. It clarifies that the governor's executive power doesn't automatically transfer functions already assigned to other authorities by existing laws, nor does it prevent Parliament or the state legislature from assigning new functions to subordinate authorities. This keeps the system flexible, allowing for, say, the creation of statutory bodies or specific agencies to carry out executive tasks, without the governor having to perform every single function directly. It prevents bureaucratic overload and allows for specialized governance.
Okay, so to give you a practical example, when the state cabinet approves a new infrastructure project or maybe an agricultural policy, the formal government orders implementing these decisions are issued in the governor's name. That's executive power being exercised through subordinate officers, in this case, the ministers and the state bureaucracy. It's an essential part of the chain of command, formally linking the elected government's decisions back to the constitutional head of the state.
And the courts have played a big role here, too. Shamsher Singh versus State of Punjab, a 1974 case, is really a landmark judgment. It firmly established that the governor, like the president, is essentially a constitutional head and must act on the Council of Ministers' advice, except in those very limited, clearly defined discretionary spheres.
Okay, that was pivotal then.
Hugely pivotal in cementing parliamentary executive principles at the state level. More recently, Nabam Rebia, in 2016, significantly curtailed the idea of sort of unfettered discretion. The court stated that even actions claimed to be discretionary by the governor are subject to judicial review if found arbitrary, malified, or unconstitutional.
So a check and balance.
A critical check on the governor's exercise of power. It reinforces the idea of limited discretionary powers they hold.
Right. These cases perfectly illustrate that concept of a parliamentary executive at state level and the carefully delineated limited discretionary powers for the governor. It seems like a delicate balance designed to ensure both democratic accountability and constitutional oversight. So how does someone actually become a governor? This is Article 155. The crucial point here seems to be it's not through popular election, but through a direct appointment by the president, making it a highly centralized process with significant federal implications.
Article 155 makes it abundantly clear. The governor of a state shall be appointed by the president by warrant under his hand and seal. This is a formal, central appointment, explicitly not an elected position. That phrase, warrant under his hand and seal, signifies the highest constitutional authority for the appointment, like a formal decree, emphasizing its gravity.
And this was a deliberate choice, wasn't it? I remember reading the Constituent Assembly debates were quite extensive on this.
They were. It was a thoroughly debated choice. They wanted to avoid creating a parallel power center if a governor was directly elected. Their fear was that an elected governor could constantly clash with an elected chief minister, potentially undermining the stability of the state government and leading to, well, constitutional gridlock. The idea was to have a link to the union, an individual appointed by the president, to maintain national unity and ensure the state government functioned within the broader constitutional framework, acting as a safeguard rather than an additional political competitor.
And crucially, the president makes this appointment on the aid and advice of the Union Council of Ministers, right? The central government.
That's the key practical point. It means the central government effectively chooses the governor. This is why the governor is often seen, and indeed often acts as, a nominee or representative of the center. This perception and reality can lead to political sensitivities, despite their legally independent constitutional office status, which was affirmed in cases like Hargovan Pant. It's a tension inherent in India's federal structure, where the union has such a direct role in state executive appointments. It's a key aspect of their role as a federal link.
So Article 155 really embodies that concept of a nominated head of state executive and distinctly highlights the governor's vital role as a federal link. It's a conscious design choice, strengthening the union's presence in the states while, in theory, still allowing for state autonomy. Okay, moving on to Article 156. This delves into a really intriguing aspect of the governor's tenure. It's primarily at the pleasure of the president. Now, the essential insight here, I think, is that while this sounds like an absolute power, the Supreme Court has significantly curtailed it, ensuring removal must be for good and compelling reasons and is subject to judicial scrutiny.
Right. Clause 1 states, "The governor shall hold office during the pleasure of the president." This is the overriding condition, making their tenure fundamentally tied to the Union government's confidence. However, Clause 3 provides a normal term of 5 years from the date they enter office. But importantly, this 5-year term is explicitly subject to the foregoing provisions, meaning the president's pleasure can cut it short at any time. Or, conversely, they can be asked to continue beyond 5 years until a successor takes over, preventing a power vacuum. This is an application of the doctrine of pleasure, known in Latin as durante bene placito, meaning during good pleasure.
Pleasure of the president. It certainly sounds absolute, doesn't it? As if a governor could be removed on a political whim. But this is where the Supreme Court stepped in, right?
Exactly. The Supreme Court introduced a critical check. In BP Singhal versus Union of India, a 2010 case, the court held that while the president doesn't have to give explicit reasons for removal, the power cannot be arbitrary, capricious, or unreasonable. There must be good and compelling reasons related to the governor's ability to discharge functions or perhaps actions prejudicial to the state or the union. Limited judicial review is available if the removal is mala fide, meaning in bad faith, or based on wholly extraneous considerations.
So, a real protection for the office.
A landmark judgment, really, to protect the constitutional dignity and independence of the governor's office.
And beyond removal, there are other ways to leave office.
Yes. The governor can also resign by writing to the president, Clause 2, providing a more graceful exit. And, critically, even after their 5-year term officially ends, they continue until his successor enters upon his office. That's the proviso to Clause 3. This is a crucial, practical safeguard preventing a power vacuum and ensuring uninterrupted governance in the state during any transition period.
So, practically speaking, a governor could technically be removed before completing 5 years if the central government loses confidence in them, provided those reasons are constitutionally sound and not arbitrary, as the Supreme Court might determine. But conversely, if a new governor isn't immediately appointed when a term expires, the incumbent stays on ensuring vital continuity in the state's executive headship. It seems like a dynamic balance between political accountability and constitutional stability.
It is. And it illustrates a prime example of the doctrine of pleasure, which has roots in English common law, but with this crucial modern-day application of constitutional conventions and, significantly, judicial oversight, as reinforced by the Supreme Court. It highlights how constitutional principles evolve through judicial interpretation in a democratic framework, striking that balance between executive power and constitutional propriety.
Okay. So what does it actually take to become a governor? What are the qualifications? Article 157? Here's a concise insight. The Constitution sets surprisingly simple foundational qualifications, citizenship and age, deliberately keeping the formal entry bar quite low.
Indeed. Article 157 sets just 2 straightforward and foundational qualifications. No person shall be eligible for appointment as governor unless he is a citizen of India and has completed the age of 35 years. That's literally it.
Just 2 things.
Just 2. These are the constitutional essentials. This brevity, I think, underscores a deliberate choice by the framers to keep the formal entry bar low, allowing for a wide pool of potential appointees based on basic constitutional loyalty and maturity, rather than, say, specific professional or political experience.
And the object of these 2 criteria is pretty simple then.
Yeah.
Ensure maturity and national allegiance. Baseline requirements for such a high constitutional office. However, the lack of other explicit qualifications, that often leads to these informal conventions and public debates, right? Like appointing an outsider to the state or consulting the chief minister.
Exactly. There's a long-standing, though not constitutionally mandated, convention of appointing an outsider to the state, the idea being to ensure impartiality from local politics. Another suggested convention is consulting the chief minister of the state before appointment, though this isn't strictly adhered to either. These informal conventions often try to fill the gaps in the sparse constitutional texts and address practical governance concerns.
And there's an interplay with another article here?
Yes, it's important to note the interplay with Article 158. While Article 157 doesn't explicitly bar a person holding an office of profit from being appointed governor, Article 158 unequivocally states the governor shall not hold any other office of profit upon assuming the governorship. so one must vacate any such office before or upon entering the governor's office. It's about ensuring undivided focus and preventing conflicts of interest once in that pivotal role of state head.
So, hypothetically, a 40-year-old academic who's an Indian citizen and has no prior political background or legislative experience could absolutely be appointed governor if they meet these two fundamental criteria. It's quite a broad net, isn't it?
It is. It shows the framers intended the role to be accessible based on basic constitutional loyalty and maturity rather than the specific career path.
Conditions, oaths, and powers of the governor. Articles 158, 162.
Okay. Beyond those basic qualifications, the Constitution sets specific conditions for the governor's office. The key insight for Article 158 seems to be that these conditions are designed to ensure independence and prevent conflicts of interest, really safeguarding the dignity and impartiality of this crucial position.
That's right. Clause 1 is vital for maintaining that independence. The governor shall not be a member of either House of Parliament or of a House of the Legislature of any state. And this isn't just a prohibition, it has an immediate consequence. If an existing MP or MLA/MLC is appointed governor, their legislative seat is automatically vacated on the date they enter upon their office.
Automatically.
Automatically. This immediately severs their formal political ties to a legislative body, significantly reducing potential conflicts of interest and ensuring their focus is solely on the gubernatorial role.
And Clause 2 reinforces this independence further, stating, "The governor shall not hold any other office of profit." This isn't just about preventing financial gain from another government position, is it?
Not at all. It's fundamentally about preventing divided loyalties or external influence that could compromise their constitutional duties. It ensures the governor's primary allegiance is solely to their constitutional office, embodying that principle of prevention of conflict of interest.
Right. And then there are provisions about their residence and salary.
Yes. Clause 3 guarantees official residences rent-free and specifies that their emoluments, their salaries and allowances are determined by Parliament by law. Until Parliament makes such a law, these are as specified in the second schedule of the Constitution. Crucially, Clause 4 states these, quote, shall not be diminished during his term of office. This provision for financial security is absolutely key to their independence. It ensures they cannot be pressured or influenced by threats of salary reduction during their tenure. It protects the independence of the head of state executive.
And what about that common governor we discussed earlier overseeing multiple states?
Ah, yes. Clause 3A cleverly details that the president determines how their emoluments and allowances are allocated and shared proportionally among the states they oversee. It's a practical solution to a unique federal arrangement, ensuring fair distribution of costs.
And that Hargov and Pant case comes up again.
It does. Hargov and Pant versus Dr. Raghukul Tilak, 1979, again affirmed the governor's independent constitutional status. This case, in particular, reinforced that these conditions protect them from being mere employees of the central government or beholden to legislative bodies. It highlights their distinct and elevated constitutional position. These articles collectively serve as sort of the constitutional armor for the governor, allowing them to act without fear or favor.
Okay. Now, before taking office, every governor undertakes a profound constitutional commitment. Article 159. The key insight here seems to be that the governor's oath is a solemn pledge to preserve, protect, and defend the Constitution, making them a crucial guardian of constitutional principles at the state level.
Absolutely. The oath detailed in Article 159 is a solemn pledge to faithfully execute the office, and critically, to the best of my ability to preserve, protect, and defend the Constitution and the law. This powerful pledge is taken in the presence of the Chief Justice of the State High Court, or, if unavailable, the senior-most judge of that court. This judicial administration of the oath underscores the governor's profound commitment to the rule of law and the constitutional framework.
That phrase, preserve, protect, and defend, it's incredibly powerful, isn't it?
Yeah.
Very similar to the president's oath.
It is, and it signifies the governor's crucial role as a guardian of the Constitution right there at the state level. It's meant to be their guiding star, especially in moments of potential constitutional crisis or when offering advice or concerns to the state government. It places a direct personal constitutional responsibility on their shoulders to uphold constitutionalism and rule of law.
And the oath concludes with a pledge to the people.
Yes, it concludes with a pledge to devote myself to the service and well-being of the people of, name it the state. This highlights their ultimate responsibility towards the state's citizens, ensuring their actions are always aimed at the welfare of the people they are appointed to serve. It ties their constitutional duty directly to public service and that guardian of the Constitution at state-level role.
Okay, what happens if the governor is suddenly unable to perform their duties and there's no immediate successor or clear plan? Article 160 seems to address this. The insight seems to be it's a constitutional safety net, giving the president residual power to address unforeseen contingencies and prevent a leadership vacuum.
That's a good way to put it. It is an enabling provision, a kind of constitutional safety net. It states, the president may make such provision as he thinks fit for the discharge of the functions of the governor of a state in any contingency not provided for in this chapter. It grants flexibility to address unforeseen circumstances that might not be explicitly covered elsewhere in the Constitution, ensuring the state always has an executive head.
So the object is just continuity.
Simple continuity. If a governor falls seriously ill, for instance, or there's some other unforeseen situation not explicitly covered by other articles, the president, acting on central government advice, of course, can, for example, appoint the Chief Justice of the High Court of that state to temporarily discharge those duties. This ensures that the state's executive functions don't just grind to a halt due to an unforeseen absence or incapacity. It illustrates the principle of prevention of constitutional vacuum. It's a very pragmatic solution for administrative and constitutional stability.
Right. Moving on to Article 161, we uncover a deeply humane power. The key insight, I think, is that the governor holds the power to grant pardons and alter sentences for offenses against state laws, acting as a crucial corrective justice mechanism, though with specific limitations compared to the president.
Exactly. Article 161 grants the governor the power to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offense against any law relating to a matter to which the executive power of the state extends. The key phrase there is matter to which the executive power of the state extends. So offenses against state laws fall within their purview. And maybe we should quickly clarify these terms.
Good idea.
Okay, so a reprieve is a temporary stay of execution. Respite means awarding a lesser sentence due to some special circumstance, like a physical disability or pregnancy. Remission reduces the term of imprisonment but doesn't change the nature of the sentence. And commutation changes the nature of the sentence, for example, from rigorous imprisonment to simple imprisonment.
Got it. And there's a really important distinction here, setting apart the governor's power from the president's, especially regarding the death sentence.
Yes, absolutely critical distinction for you to understand. While the governor can suspend, remit, or commute a death sentence, they cannot grant a full pardon for it. That ultimate power to completely absolve a person from a death sentence resides exclusively with the president under Article 72.
Okay. President only for full pardon on death sentence.
Correct. Also, court-martial sentences, which come from military tribunals, are solely the president's domain. The governor has no jurisdiction over them. This clearly delineates the powers between the union and state executives in matters of clemency.
And how is this power exercised? On advice.
Generally, yes. Like other executive powers, this is normally exercised on the aid and advice of the State Council of Ministers. However, and this is important, the Supreme Court in Apur Sudhakar versus Government of Andhra Pradesh, 2006, clarified that this power, while broad, is subject to limited judicial review. This means the courts can intervene on grounds like arbitrariness, mala fides, bad faith, non-application of mind, or if the decision is based on wholly extraneous considerations. It's not an unfettered power, it must be exercised with reason and fairness.
So again, checks and balances.
Exactly. It ensures that the prerogative of mercy clemency at state level, while offering a corrective justice mechanism, is balanced with constitutional accountability.
So if a person is convicted under, say, a state excise act for an offense and gets their sentence remitted by the governor, that's a direct application of Article 161. Or a death sentence from a state court might be commuted to life imprisonment by the governor. But for that ultimate full pardon from a death sentence, the petition would have to go to the President of India. It's a crucial hierarchy of clemency powers reflecting that federal structure.
Perfectly summarized.
Now, how far does a state government's executive reach? What are its operational boundaries? Article 162 seems to define this. The core insight appears to be that a state's executive power generally mirrors its legislative power, but Parliament can assert union executive authority in concurrent matters.
Generally speaking, yes. The executive power of a state shall extend to the matters with respect to which the legislature of the state has power to make laws. This means it covers subjects in the state list and the concurrent list of the 7th schedule of the Constitution. So, if the state legislature can make a law on public health, for example, the state executive can then act on policies and administration related to public health. This defines the primary operational domain of the state government.
But there's a catch for the concurrent list, right, where both Parliament and states can legislate.
There is. There's a crucial proviso for concurrent list subjects. If Parliament makes a law on a concurrent list subject and expressly confers executive power on the Union, or its authorities for that matter, then the state's executive power in that specific area is limited by the Union's. This is key to maintaining federal balance and ensuring that central laws, when they specifically mandate central execution, are indeed carried out by the Union, asserting national uniformity where deemed necessary.
Interesting. And can the executive act even without a specific law?
Yes. Interestingly, Ramjawaya Kapoor versus State of Punjab back in 1955 established a broader principle. The Supreme Court clarified that executive power isn't limited to merely implementing existing laws. It includes all governmental functions that are not legislative or judicial. It can even be exercised without specific prior legislation, as long as it doesn't violate any existing law or fundamental rights. This gives the state executive a wide scope for proactive governance and policymaking in areas where the legislature hasn't yet acted.
Okay, so to illustrate, a state can independently run its health system and implement public health policies because health is a state list subject. On education, which is concurrent, a state can implement its own laws. However, if a central law on, say, environmental protection gives specific executive powers to a national body, then the state's power in that specific area of environmental protection would be restricted and subject to the Union's authority.
Exactly. This article is really the core of coextensiveness of legislative and executive power, state level, and outlines the federal distribution of executive power within India.
The State Council of Ministers, Heart of State Governance, Articles 163 to 164.
Okay, so if the governor is the constitutional head, who really runs the show day to day, who takes the decisions and implements policies, Article 163 seems crucial here. The core insight seems to be the Council of Ministers, led by the chief minister, is the actual executive, largely binding the governor with their advice, though the governor retains that very narrow, judicially reviewed discretionary sphere.
Precisely. Clause 1 states the general fundamental rule of parliamentary democracy at the state level. There shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his functions. This is a mandatory constitutional provision, making the council of ministers the de facto executive. In a parliamentary system, the governor is generally expected, indeed constitutionally bound in most cases, to act on this advice, effectively making the council of ministers the real decision-making body.
But there's that exception again, the discretionary powers.
Right. The clause also adds that vital exception, which is where the governor's unique role shines through. Except insofar as he is by or under this Constitution required to exercise his functions, or any of them in his discretion. These are those sensitive, constitutionally mandated moments we discussed earlier. Think again of inviting a leader to form a government in a hung assembly, submitting a report for president's rule under Article 356, or reserving certain bills passed by the state legislature for the president's consideration. These are the few situations when the governor acts without direct ministerial advice.
And Clause 2 says the governor's decision on whether something falls under discretion is final. That sounds pretty absolute.
It sounds absolute. It says the governor's decision on whether a matter falls under their discretion shall be final. However, as we mentioned, Nabam Rebia 2016 made it emphatically clear that this finality does not bar judicial review if that discretion is exercised arbitrarily, malified, or unconstitutionally.
Another crucial check and balance, then.
Absolutely. It prevents the misuse of discretionary powers and ensures constitutional discretion limited.
And Clause 3 deals with the confidentiality of advice.
Yes, it maintains the confidentiality of government functioning. The question whether any, and if so what, advice was tendered by ministers to the governor shall not be inquired into in any court. This provision protects the internal deliberations and frank advice exchanged within the executive, ensuring ministers can advise freely without fear of judicial scrutiny of their specific recommendations. It safeguards the sanctity of cabinet discussions.
And the key court cases here, Shamshir Singh again.
Shamshir Singh versus State of Punjab, 1974, is foundational, unequivocally stating the governor is bound by ministerial advice except for those very limited, constitutionally specified discretionary spheres. Later, S.R. Bama in 1994, which heavily scrutinized the governor's role in president's rule, and Nabamribia, 2016, further defined and significantly limited the scope of that discretion, particularly concerning sensitive actions like assembly dissolution. These cases have collectively strengthened the principle of a responsible elected executive, illustrating responsible government at state level.
Okay, building on that, Article 164 provides the granular detail for the ministers themselves. The key insight here seems to be it defines how ministers are appointed and held accountable, and crucially, it introduced reforms that cap cabinet size and disqualify defectors, strengthening the democratic legitimacy of ministers.
Right. Clause 1 states the chief minister is appointed by the governor, who usually invites the leader of the majority party or coalition in a legislative assembly. Other ministers are then appointed by the governor on the advice of the chief minister. They all hold office during the pleasure of the governor, which, in practice, means the chief minister can recommend their removal as the governor acts on the CM's advice in this matter. This reinforces the responsible cabinet government state-level principle.
And there's a special provision for tribal welfare ministers in some states.
Yes, a unique and very important provision in Clause 1 mandates a minister specifically in charge of tribal welfare in certain states, like Chhattisgarh, Jharkhand, Madhya Pradesh, and Orissa. This isn't just an administrative detail. It reflects a deep constitutional commitment to the welfare and upliftment of vulnerable tribal communities, acknowledging their specific needs and requiring dedicated representation at the highest levels of state governance. It's a testament to the Constitution's focus on inclusive development.
And then came the 91st Amendment reforms. Those seem really significant.
Hugely significant. Clauses 1A and 1B, introduced by the 91st Amendment in 2003, were absolutely brilliant reforms designed to address chronic political issues. Clause 1A caps the total number of ministers, including the chief minister, at 15% of the Legislative Assembly's strength, with a minimum floor of 12 ministers.
Why was that needed?
It was a direct response to the problem of huge, oversized cabinets, jumbo cabinets they were called, often used for political appeasement and rewards. These often led to inefficiency and significant financial strain on the state exchequer.
Okay, so it prevents that. And Clause 1B?
1B directly addresses political instability caused by defections. It disqualifies a defector, that is, a member who changes political parties and gets disqualified under the 10th schedule, the anti-defection law, from being appointed as a minister until they're reelected. This closed a loophole that allowed defectors to be immediately rewarded with ministerial positions, thus strengthening party discipline and, hopefully, government stability.
Right. And Clause 2 is about collective responsibility, the linchpin of the system.
Exactly. It's the core of parliamentary democracy. The Council of Ministers shall be collectively responsible to the Legislative Assembly of the state. This means the entire council sinks or swims together. If a no-confidence motion passes against the government in the Assembly, the whole Council of Ministers must resign. It reinforces their direct, collective ministerial responsibility to the elected representatives.
Okay. And ministers take oaths, and there's that 6-month rule?
Yes. Ministers take oaths of office and secrecy before the governor, as prescribed in the 3rd Schedule, Clause 3, pledging to faithfully discharge their duties and maintain confidentiality. And Clause 4 has that crucial 6-month rule. A person who is not already a member of the state legislature, either assembly or council, can be appointed as a minister, but they must become a member of the state legislature within 6 consecutive months from their appointment. Otherwise, they cease to be a minister.
So they can't just stay a minister without being elected or nominated?
No, this ensures that ministers ultimately derive their legitimacy from democratic representation and are accountable to the legislature.
And court cases have refined this, too.
Yes, landmark cases have shaped interpretation. S.R. Chaudhary v. State of Punjab, 2001, clarified the 6-month rule, preventing its misuse for repeated appointments of non-legislators. The court basically said the 6-month period is a one-time opportunity per legislative term. Similarly, B.R. Kapoor v. State of Tamil Nadu, 2001, reinforced that a legislator disqualified under other laws cannot be appointed as a minister, upholding the integrity of the ministerial office. Together, these clauses create a really robust and accountable executive structure for India's states.
Understanding state legislatures' upper house and duration, Articles 171 to 172.
Okay, let's shift gears now and explore the state legislatures themselves, starting with the legislative councils in states that have them, the Vidhan Parishad. For Article 171, the key insight seems to be that these upper houses are deliberately designed for functional representation, bringing diverse voices and expertise into the legislative process, rather than simply mirroring the directly elected assembly.
That's a great way to capture it. Clause 1 sets the strength limits for these legislative councils. Its size shall not exceed 1/3 of the total number of members in the legislative assembly of that state, and in no case be less than 40. This ensures the upper house isn't disproportionately large compared to the assembly, but still maintains a respectable minimum size to function as a deliberative body. And remember, the Seventh Amendment back in '56 was key here, changing the maximum strength from 1/4 to 1/3, allowing for slightly larger councils as states grew.
Right. And this is where it gets really interesting for you, our listeners, especially if you care about multiple perspectives. Clause 3 carves out representation for incredibly diverse interests. It's quite a mix, isn't it?
It really is. Roughly 1/3 are elected by local authorities like municipalities and district boards, bringing grassroots perspective. Then 1/12 are elected by graduates of at least 3 years standing, reflecting, intellectual contributions.
Graduates.
Yeah. Another 1/12 are elected by teachers with at least 3 years experience in secondary or higher education, bringing educational expertise. Then 1/3 are elected by the MLAs themselves from people who are not MLAs. And finally, the remainder, about 1/6, are nominated by the governor for special knowledge or practical experience in fields like literature, science, art, the cooperative movement, and social service that's outlined in Clause 5. It's a truly unique, multi-layered blend designed for broad representation.
And the election method for these categories is also specific.
Yes. Crucially, Clause 4 specifies that elections for these various categories, local authorities, graduates, teachers, and MLAs, are held by proportional representation by means of the single transferable vote. This system is designed precisely to give a voice to various groups and minorities, rather than just favoring simple majority rule, ensuring a more inclusive and representative composition in the council. This highlights bicameralism at state level, which, remember, is optional for states and deliberately structured for this functional representation.
Okay, so how long do these legislative bodies actually last? Is it a fixed term, or can they be dissolved early? Article 172 clarifies the very different terms for the Assembly and the Council. The key insight seems to be that the Assembly has a periodic democratic mandate with a fixed term and the potential for dissolution, while a Council provides continuity of legislative chamber as a permanent, non-dissolvable body.
That's the core difference. Clause 1 sets the normal term for the Legislative Assembly at 5 years from the date appointed for its first meeting. And the Constitution is quite emphatic and no longer. This ensures periodic democratic renewal and accountability to the electorate. However, as we noted earlier, it can be sooner dissolved by the governor, usually on the chief minister's advice or in specific discretionary circumstances.
And that 5-year term was restored after being changed.
Yes, it's worth remembering that the 44th Amendment in 1978 restored this 5-year term after the 42nd Amendment in 1976 had controversially extended it to 6 years during the emergency period. This restoration emphasizes the importance of this regular democratic cycle.
And there's a provision for emergencies.
Yes, a fascinating proviso here shows the Constitution's adaptability for crises. During a proclamation of emergency, Parliament can extend the Assembly's life by law, not exceeding 1 year at a time. But critically, it can extend beyond 6 months after the emergency itself ends. This ensures continuity and avoids immediate elections during national crises, but also prevents indefinite extensions of power. A carefully balanced provision.
Right. And the Legislative Council's completely different.
Completely different. In stark contrast, Clause 2 declares, "The Legislative Council of a state shall not be subject to dissolution." Like the Rajya Sabha at the union level, it's designed to be a permanent, continuing chamber. Instead, to ensure fresh perspectives while maintaining institutional memory, as nearly as possible, 1/3 of the members thereof shall retire on the expiration of every second year.
So members rotate out.
Exactly. This rotating membership ensures fresh blood while preserving institutional memory and continuity. Individual members typically serve 6-year terms, but the House itself is permanent.
Okay, so to give you a clear picture, a state assembly completes its 5-year run, and then new general elections are held. But a legislative council, once formed, just keeps rolling, with individual members serving 6-year terms and roughly 1/3 of its members rotating out every 2 years. It's a constant, evolving body designed for stability.
Precisely. And cases like S.R. Bommai versus Union of India in 1994, while primarily about president's role, they did underscore the sanctity of the Assembly's 5-year term. The Supreme Court emphasized that dissolution, particularly by a governor, should not be arbitrary and must be based on objective material. This reinforced the democratic expectation of the Assembly's fixed tenure and that principle of a periodic democratic mandate.
Legislative membership, sessions, and governor's legislative role, Articles 173, 177.
All right, so who gets to be a lawmaker in a state legislature? What are the entry requirements? Article 173 sets the basic constitutional bar. The key insight here seems to be that it ensures fundamental standards, citizenship, age, and an oath, while allowing Parliament to prescribe uniformity and additional qualifications across all states.
That sums it up well. To fill a seat in the legislature of a state, a person must meet specific criteria. First, obviously, they must be a citizen of India. Secondly, and crucially, they must make and subscribe an oath or affirmation. The text is in the third schedule, pledging allegiance to the Constitution and upholding India's sovereignty and integrity. This oath is typically administered by a person authorized by the Election Commission before they file nomination papers.
And then there's age.
Yes, age-wise, it's not less than 25 years of age for the Legislative Assembly and not less than 30 years of age for the Legislative Council. Higher age for the upper house, supposedly for more maturity.
Okay. And Parliament sets other qualifications, not the state.
Right, that's an important point for uniformity across the nation. Clause C allows Parliament, not the state legislature itself, to prescribe, quote, such other qualifications as may be prescribed by law. This is vital because it ensures that additional qualifications, like for instance being an elector in the state, which is required by the Representation of the People Act 1951, are consistent for all states. It prevents arbitrary or discriminatory state-specific rules and reinforces the eligibility for public legislative office state level.
Okay, so to illustrate, a 23-year-old, even if a brilliant Indian citizen, simply cannot run for the Legislative Assembly because they haven't met the age requirement. But a 32-year-old citizen can run for either the Assembly or the Council, provided they meet those other parliamentary qualifications. And before nomination, a candidate must solemnly take that oath, publicly affirming their commitment to the Constitution.
Exactly. And Pashupati Nath Sukul versus Nemchandra Jain, 1984, confirmed that the oath under Article 173A is a mandatory condition and must be completed by the time of nomination scrutiny. It emphasizes its crucial role as a constitutional prerequisite for candidacy.
Got it. Now, who controls when the state legislature meets, when a session ends, and crucially, when the assembly is dissolved? Article 174. The key insight here seems to be that these critical powers, which define the executive control over legislative timetable, rest with the governor, ensuring a balance between executive prerogative and legislative accountability.
Right. Clause 1 states, "The governor shall from time to time summon the House or each House to meet at such time and place as he thinks fit." This power is generally exercised on the advice of the State Council of Ministers, but there's that crucial constitutional check we mentioned. 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. This ensures the legislature meets at least twice a year and cannot be kept in indefinite abeyance, safeguarding legislative oversight.
And Clause 2 gives the governor two distinct powers: prorogue and dissolve.
Yes, two distinct and powerful actions. First, A, to prorogue the House, or either House. This ends a session of the legislature, but the life of the Assembly, or Council, continues. Bills generally don't lapse when a House is prorogued. They carry over to the next session, unless specifically excluded by the rules.
Okay, session ends, but the assembly lives on.
Exactly.
Yeah.
Second, B, to dissolve the Legislative Assembly. This is far more drastic. It ends the life of the Assembly entirely, triggering fresh elections and seeking a new popular mandate. The Council, remember, being permanent, is never dissolved.
Right. And the governor's discretion in dissolving the assembly, that's where the controversy often lies.
That's often the flashpoint. While these powers are generally exercised on ministerial advice, the governor's discretion in dissolving the assembly, especially in times of governmental instability, like a hung assembly or when a chief minister loses majority support, has been a hotbed of constitutional debate. Nabam Rebia, 2016, again emphasized that this discretion is not unfettered and must be exercised constitutionally and for legitimate reasons, not arbitrarily or to serve political ends. This ensures the accountability of state government through dissolution isn't abused.
So practically, when the state cabinet advises the governor to call the monsoon session, that's Article 17400, in action, the governor then prorogues the House after its business is concluded, ending that session. Or if a government loses its majority, the governor might, in exercising their limited discretion, dissolve the assembly to seek a new popular mandate through fresh elections. It shows that dynamic interplay.
It does. And S.R. Bomai, 1994, extensively reviewed the governor's dissolution powers, stressing judicial review if the action is nullified, reaffirming the limits. Nabam Rebia, 2016, Further reinforce this, even setting aside a governor's actions deemed arbitrary in summoning or dissolving the assembly. These cases highlight the judiciary's crucial role in ensuring constitutional propriety here.
Okay. Beyond calling sessions, the governor also maintains a direct line of communication with the state legislature, Article 175. The key insight seems to be that it establishes the governor's formal right to address and send messages, functioning as a vital communication between head of state executive and legislature.
That's right. Clause 1 allows the governor to address the legislative assembly or either house or both houses assembled together and may for that purpose require the attendance of members. This is their opportunity to convey their views or concerns. Though usually on the advice of the Council of Ministers, it can, in certain circumstances, be a formal way of communicating directly.
And they can send messages, too.
Yes. Clause 2 has the power to send messages to the House or houses, whether with respect to a bill then pending or otherwise. And here's the kicker, a constitutional obligation. The receiving House shall with all convenient dispatch consider any matter required by the message.
So they have to consider it.
They have a constitutional duty to pay attention and deliberate on the matter the governor deems important. It's not just a suggestion. This reinforces the governor's role as an integral part of the state legislature, allowing them to draw attention to important issues or offer suggestions on legislation. While typically exercised on advice, in rare discussionary moments, like perhaps formally suggesting amendments to a bill they are considering reserving for the president, it could be a way for the governor to formally voice constitutional concerns to the legislature. It signifies a limited facet of the governor's role as advisor guide.
So the governor might send a message to the assembly urging reconsideration of certain clauses in a controversial bill, or maybe highlighting the urgent need for new legislation on disaster management. And the assembly then has a constitutional duty to consider that message promptly.
Precisely.
Okay, closely related to that is Article 176, which mandates a special address by the governor. The key insight here seems to be that this is a mandatory, high-profile ceremonial opening prepared by the state government that serves as a vision statement and a crucial moment for accountability of state executive to legislature.
Exactly. The governor shall address the assembly, or both houses if bicameral, at two specific mandatory times: at the commencement of the first session after each general election, and at the commencement of the first session of each year. In this address, which is prepared by the state cabinet, the governor informs the legislature of the causes of its summons, which is essentially the state government's policy statement and legislative program for the upcoming period. It's a formal declaration of intent.
And this leads to the motion of thanks.
Yes. Clause 2 mandates that time shall be allotted for discussion of this address. This usually culminates in a motion of thanks, moved by a member of the ruling party. A defeat of this motion in the Legislative Assembly can be a really big deal. It's often considered equivalent to a vote of no confidence against the government itself, potentially leading to its collapse. It's a moment of significant political theater and scrutiny.
So a key accountability moment.
Absolutely. The object is to formally declare the government's agenda to the legislature and, through it, to the people of the state, and it serves to allow for legislative debate and scrutiny of those policies. It's a crucial moment for accountability of state executive to legislature, setting the stage for the legislative year.
Got it. Finally, for this segment, Article 177 addresses how state ministers and the top legal advisor, the Advocate General, interact with the legislative bodies. The key insight is that this article grants them crucial participatory rights in legislative proceedings without the right to vote, fostering coordination between state executive and legislature.
Right. The article covers two specific categories. Every minister and the Advocate General for a state, it grants them the right to speak in and otherwise to take part in the proceedings of the Legislative Assembly or both houses. They can also participate in any committee of the legislature if they're named a member of that committee. This ensures they can present their views and government policy directly to the lawmakers, allowing for clear articulation of the executive stance.
But they can't vote unless they're a member of that house.
Exactly. That's the key limitation. They shall not, by virtue of this article, be entitled to vote. A minister can only cast a vote in the House of which they are actually a member. The Advocate General, not being a legislator, never votes. So while they have a voice to explain and defend, they do not have a vote in a chamber where they aren't elected members.
And this facilitates accountability.
Directly. It facilitates ministerial accountability to state legislature. Ministers can explain and defend government policies, pilot bills through the houses, and answer questions in either house, even if they aren't a member of that specific house. It also allows the Advocate General, the state's highest law officer, to provide vital legal expertise directly to the legislature, clarifying legal aspects of bills or policies, thereby enhancing informed decision-making.
Okay, so imagine a health minister who happens to be an MLC, a council member, presenting detailed policy points and taking tough questions in the Legislative Assembly about a new health initiative. They can speak, clarify, debate, but they can't actually cast a vote in the Assembly. Or consider the Advocate General advising a legislative committee on the complex legal implications of a proposed bill. This bridging role seems crucial for effective governance.
It absolutely is. It ensures that connection between the executive and the legislature functions smoothly.
Offices of the state legislature speakers, chairman, and secretariat, Articles 178 to 190.
Okay, let's turn our attention now to the leadership within the state legislatures. Articles 178 through 185 cover the Speaker and Deputy Speaker of the Legislative Assembly and the Chairman and Deputy Chairman of the Legislative Council. The overarching insight here, I think, is the constitutional commitment to the presiding officer's impartiality and the clear mechanism set up for continuity of legislative business and accountability to the elected House. These roles seem absolutely essential for maintaining order and democratic procedure.
Absolutely essential. Article 178 mandates that every legislative assembly of a state shall, as soon as may be, choose 2 members of the assembly to be respectively Speaker and Deputy Speaker. They are elected directly from amongst the assembly's own members, which underscores the internal autonomy of the House. And the Speaker is much more than just a moderator, right? They are a pivotal figure. They interpret the rules of procedure, maintain order and decorum during often heated debates, certify money bills at the state level, which is a crucial financial power, and they guard the rights and privileges of the House and its members. Their impartiality is paramount.
Right, the guardian of legislative privileges. And the Deputy Speaker is equally important for continuity.
Yes, they step in when the Speaker's office is vacant or when the Speaker is simply absent from a sitting. This ensures that the Assembly's proceedings can continue without interruption.
And how do they leave office? Article 179 covers this.
Yes, Article 179 outlines the modes of vacancy. They must vacate if they cease to be a member of the Assembly. They can resign. The Speaker resigns to the Deputy Speaker and vice versa. And crucially, they can be removed by a resolution of the Assembly passed by a majority of all the then members of the Assembly.
An effective majority.
Exactly, an effective majority, not just a simple majority of those present and voting. And this can only happen after at least 14 days' notice, ensuring procedural fairness in removal.
And there's that interesting detail about the Speaker continuing after dissolution.
Yes, that's a really interesting point in Article 179, designed for smooth transitions. Whenever the Assembly is dissolved, the Speaker shall not vacate his office until immediately before the first meeting of the Assembly after the dissolution. This ensures someone is there to oversee the new Assembly's very first steps, perhaps administer oaths to newly elected members, and conduct the election of the new Speaker, a vital continuity of presiding office function that prevents a leadership void right at the start.
That makes sense. And Article 180 reinforces this continuity if the Speaker is unavailable.
Yes, it outlines a clear hierarchy for who presides if both the Speaker and Deputy Speaker are unavailable, ensuring continuity of presiding authority so the House can always function.
Okay. And what happens if the Speaker or Deputy Speaker themselves face a resolution for removal? Can they preside over their own, judgment?
Absolutely not. Article 181 directly applies that core principle of natural justice, nemo judex in causa sua, no one should be a judge in their own cause. While they retain the right to speak and participate in the proceedings concerning their removal, they are strictly prohibited from presiding over the House when that resolution is under consideration.
But they can vote.
They can vote, but only as an ordinary member in the first instance. They do not get to use a casting vote in case of a tie on their own removal motion.
Right, okay. And similar provisions exist for the Legislative Council's chairman and deputy chairman, Articles 182 onwards.
Very similar structure. Article 182 states, "The Legislative Council shall, as soon as may be, choose 2 members of the Council to be respectively chairman and deputy chairman thereof." Again, elected from among the MLCs themselves.
And this is different from the Rajya Sabha chairman.
Yes, that's a key difference from the Union Parliament. The Rajya Sabha chairman is the Vice President of India, an ex officio role. But the State Legislative Council chairman is elected by and from its own members, emphasizing the self-governance of legislative chambers at the state level.
Okay. And Article 183 mirrors the vacancy and removal provisions for the Assembly's officers.
Exactly. Ceasing to be an MLC resignation, or removal by a council resolution with 14 days' notice. Article 184 ensures continuity of legislative business for the council if the chairman or deputy are absent. And Article 185 extends that nemo judex in causa sua principle to the council's presiding officers during their own removal proceedings, prohibiting them from presiding. It ensures procedural fairness across both houses.
Makes sense. Now, to ensure their independence and dignity, these presiding officers get salaries and allowances. That's Article 186. The key insight seems to be that these emoluments are determined by the state legislature itself and are charged on the consolidated fund, which is crucial for the independence of presiding officers.
That's right. Article 186 states that their salaries and allowances as may be respectively fixed by the legislature of the state by law. Until such a law is made, they are as specified in the second schedule of the Constitution. So the state's own legislature controls this.
And being charged on the consolidated fund means they aren't voted on annually.
Correct. These emoluments are typically charged on the consolidated fund of the state, meaning they are non-votable by the legislature during the annual budget process. This financial independence is a crucial detail. It contributes significantly to their ability to act impartially without direct financial pressure from the executive or the legislative members during annual budget reviews.
Right. Truly underpins their independence. Okay, beyond the lawmakers and their leaders, who keeps the entire legislative machinery running smoothly day to day? Article 187 provides for the Secretariat of State Legislature. The key insight here seems to be the administrative independence of the legislature, a foundational aspect of the separation of powers.
Absolutely foundational. Clause 1 states, "The House, or each house of the legislature of a state, shall have a separate secretarial staff." This is fundamental. It ensures the legislature's administrative support, the people who handle drafting, records, research, administration, is independent of the executive branch of the state government.
Preventing executive interference.
Exactly. In bicameral states, the proviso allows for common posts for both houses if deemed efficient, but the principle of separation remains.
And the legislature controls its own staff.
Yes. Clause 2 gives the state legislature the power to regulate staff recruitment and conditions of service by law, granting them full autonomy over their administrative backbone. But until such a law is made, Clause 3 allows the governor, importantly, after consultation with the speaker or the chairman, to make interim rules. This consultation is key, ensuring the presiding officers have a say even before a permanent law is enacted.
And court cases have backed this independence.
Yes. Cases like State of UP vs. CM Srivastava, 1984, affirm the independent status of the legislature secretariat and the control of presiding officers over their staff. This independence isn't just about avoiding executive interference. It's about the very efficiency and integrity of the legislative process itself. It reinforces separation of powers, administrative autonomy.
Okay. Article 188, though brief, seems fundamental. It mandates that every member of a state legislature must make and subscribe an oath or affirmation before taking their seat. The insight is that this is a direct and personal pledge of allegiance, ensuring a foundational commitment to the Constitution from every legislator.
It is exactly that, a direct personal pledge of allegiance to the Constitution of India and a commitment to upholding the sovereignty and integrity of the nation. It ensures that all legislators, regardless of their political affiliation or background, are bound by the same constitutional principles before they can participate. It's a foundational step, formally acknowledging their duties.
Right. Next, Article 189 defines the essential rules of engagement for legislative proceedings, how decisions get made. The key insight seems to be that it establishes mechanisms for efficient decision-making by majority vote, ensures legislative validity despite vacancies, and mandates a quorum to ensure meaningful participation.
That covers it well. All questions at any sitting are determined by a majority of votes of the members present and voting. This excludes the speaker or chairman unless they need to cast a tie-breaking vote. Casting vote. Standard procedure.
And the legislature can still function, even with empty seats.
Yes, that's a crucial provision for maintaining legislative function. The power of the legislature of a state to act notwithstanding any vacancy in the membership thereof. This means the legislature can still conduct business and pass laws, even if some seats are empty due to resignations, disqualifications, or delayed elections. The validity of proceedings cannot be questioned just because a seat was vacant, a highly practical measure to prevent paralysis.
But there's a minimum attendance needed. The quorum.
Yes, there's a minimum attendance requirement to ensure meaningful deliberation. This is the quorum. The quorum for a meeting is 10 members, or 1/10 of the total number of members of the House, whichever is greater. If there's no quorum, the speaker or chairman must immediately adjourn or suspend the meeting until the required number of members are present. This ensures decisions are made by a sufficiently representative body.
So these rules ensure the legislative process is efficient, legitimate, and can function even with disruptions, while still requiring a meaningful number of members for decisions. Balances practicality with democracy.
Well put.
And finally, Article 190 details the circumstances under which a member of a state legislature might vacate their seat. The key insight is that it ensures clarity and order regarding legislative membership by preventing dual roles and ensuring active participation.
Right. First, a person cannot be a member of both houses of the state legislature, nor a member of both parliament and a state legislature simultaneously. That's dual membership. If elected to multiple, they must choose one seat to retain within a specified period, or one seat is automatically vacated. This prevents individuals from holding multiple legislative offices.
Okay. And other reasons: disqualification, resignation.
Yes, seats can also be vacated due to disqualifications like those under Article 191, which covers things like holding an office of profit, being of unsound mind, insolvency, or certain criminal convictions provisions closely related to our discussion, or simply by resignation submitted to the speaker or chairman.
And being absent for too long.
Yes, a member can also vacate their seat if they are absent from all meetings for a period of 60 days without permission of the House. This 60-day rule is a mechanism to ensure active participation and prevent prolonged absenteeism.
So this article is really about ensuring clarity and order regarding legislative membership and preventing conflicts arising from dual roles or just plain non-participation.
Yeah.
It maintains the integrity and active functioning of the state's democratic institutions.
Exactly. It sets clear rules for who occupies a seat in the legislature and under what circumstances they leave it. Outro.
Wow. Okay. What an incredible journey, really, through the constitutional heart of India's states. We've truly unpacked quite a lot. Everything from that unique pre-2019 definition of a state and its implications for Jammu and Kashmir to the governor's multifaceted role, from constitutional head to union link, with a fascinating look at their limited discretionary and pardoning powers, and then the vital council of ministers, the nuances of the legislative councils, and those critical officers in the administrative backbone that ensure the smooth functioning of state assemblies.
It's quite a structure. And through it all, we've seen how India balances or tries to balance a strong center with robust state autonomy. We've seen the delicate interplay of parliamentary conventions versus the actual constitutional text, and how the Supreme Court has repeatedly stepped in to interpret and, at times, constrain the exercise of power to uphold the spirit of the Constitution. The provisions for the governor's office, particularly their limited discretionary powers and the judicial scrutiny applied to them, the 91st Amendment's really brilliant reforms for ministerial size and defection, and that intricate, functionally representative composition of legislative councils, they truly showcase the foresight and, I think, the adaptability of India's constitutional architects.
Absolutely. So next time you hear about a state election or a governor's decision or maybe a heated debate in a state legislative assembly, hopefully, you'll have a much deeper understanding of the constitutional scaffolding that supports it all. You'll recognize the layers of power, the intricate mechanisms of accountability, and the ingenious designs, intended at least, to prevent chaos and ensure effective governance across this vast and diverse nation. You're now equipped, hopefully, to look beyond the headlines and grasp the constitutional underpinnings.
And maybe a final thought to leave you with. Given the dynamic nature of federalism and parliamentary democracy, consider this. How might the increasing scrutiny of the governor's discretionary powers, something we've seen in recent Supreme Court judgments, how might that reshape the political relationship between the union and the states in the coming decades? And perhaps more importantly, how might that impact the actual day-to-day lives of citizens like you who rely on effective state governance? It's a question worth pondering, I think, as you navigate the fascinating and ever-evolving landscape of constitutional governance in India.
A really pertinent question to end on. Thank you for joining us on this deep dive.